We would like to start the discussion on panel number 5. The topic for this panel is Resolution to Revenue, How ADR Shapes Foreign Direct Investment. This panel shall be moderated by Mr. Duncan Backshaw, who is a partner at Howard Kennedy, London, and he will be discussing on the symphony between ADR and FDI, explaining the direct proportionality between ADR and FDI inflows. Our first speaker in this panel is Mr. Shahbakh Pirzada, who is a partner at Ria Barker Gillett, and he will be discussing on FDI's perspective in comparing global ADR practices in FDI. Our second speaker is Mr. Kevin Nash, who is the registrar for the Singapore International Arbitration Center, and he will be discussing on tracing the development of ADR in the region and discussing current trends and envisioning future trajectories. Our second last speaker in this panel is Mr. Hassan Manviwala. He's a partner at Manviwala and Zafar, Karachi, and he will be sharing his thoughts on the effectiveness of our legal landscape in attracting foreign direct investment. Our last speaker in this panel is Honorable Mr. Justice Yusuf Ali Syed, who's the judge of the Sindh High Court, and he will be sharing his thoughts on the initiative that the government should take in providing efficient ADR mechanism that leads to increasing FDI in Pakistan.
Good evening, ladies and gentlemen. I hope you can hear me clearly. I'll try and place the microphone so that there's no difficulty. Honourable judges and distinguished ladies and gentlemen, it's an honour to have been invited to moderate this very distinguished panel of speakers. We've agreed to adopt in this session an informal question and answer style, and we will be remaining in our seated positions with no disrespect meant to the eminent speakers. We thought that this would be a more lively and engaging style to take late in the day on a Sunday. Our theme for this session is Resolution to Revenue, How ADR Shapes Foreign Direct Investment. And during the discussions over the course of this weekend, there have been several references to the potential interaction between ADR and FDI, and also mentioned during the course of the discussions LDI, local direct investment. In this panel, we're going to take a deeper look at the subject and examine in more detail the link between ADR and FDI. We'll consider a number of matters. First, the availability of dispute resolution mechanisms and its effect on the appetite of investors. Second, the impact of the processes and procedures of dispute resolution on their appetite. And third, the projects and the fiscal framework for those projects into which investment is made and its effect on investment appetite. Now, this is a controversial subject. One may contrast, for example, in 2018, Doctors Frenkel and Walter published a report in the World Economy Journal which found that ISDS provisions in bilateral investment treaties have a direct effect to promote FDI in the jurisdictions which are parties. However, in 2022, in the British Journal of Political Science, Messrs. Kerner and Christoph found that ISDS provisions on dispute resolution make little or no difference to the appetite of investors for FDI, even when the state has a track record of contesting and losing ISDS claims. It has little impact. At the same time, the number of investment treaty cases which are brought is growing all the time. Since the UNCITRAL Working Group 3 sessions began in 2017, up till last year, 442 ISDS cases were started, in 29 of which the damages demanded were in excess of $1 billion. We've also seen states in Central America and Africa in particular announcing their intention to withdraw from BITs or to make new BITs which offer, they would say, a more balanced protection for investors and protection of the state's rights to regulate and legislate. I'm going to briefly introduce our speakers, if I may. I can't do justice to all of their achievements in just a few minutes. Starting on my far left with the Honourable Mr. Justice Yusuf Ali Syed, who is an additional judge of the Sindh High Court and is the designated monitoring judge of District Saeed Benazirabad. He studied both in Pakistan and in England, and he practiced as an advocate before the High Court and the Supreme Court as a civil litigator. He's both been a lecturer at SM Law College and Hamdard Law University, and he's served on the appellate and election tribunals. He's also a member of the Information Technology Committee of the court, and so has one eye firmly on the future. Secondly, Mr. Kevin Nash in the middle is the registrar of the Singapore International Arbitration Centre. He leads the SIAC Secretariat in the provision of case management services. He's overseen the administration of thousands of international arbitration cases under the SIAC rules and also under the UNCITRAL arbitration rules. He has participated in both UNCITRAL Working Group 2 on dispute settlement and 3 on ISDS, and he's spoken and lectured on several contemporary issues in international arbitration at events all over the world. He's described in one of the directories I noticed as a rock star of arbitration, so I'm hoping he's going to play some of his hits for us today. Next to me is Shabakt Pizada. He is a partner at Riyad Barker Gillette, a leading law firm here in Pakistan, as you will all know. He specializes in advising representing clients in complex commercial disputes, often across multiple jurisdictions. He's assisted several international arbitration tribunals and courts in addressing questions of Pakistani law. His clients include leading companies in the oil and gas, power, shipping, insurance, and financial services sector. And last, but very much not least, is Hassan Manviwala. Hassan is a commercial and disputes lawyer at Manviwala and Zafar here in Karachi. He's an English law graduate. He has qualified both as a solicitor in England and as a barrister of Lincoln's Inn. He is the national representative for Pakistan for the IBA, and he occupies a position as the officer of the Anti-Money Laundering Committee of the IBA and the Young Lawyers Committee. He's recently spoken at the IBA Distribution and Supply Chain Conference in Washington, D.C., and before the Senate Standing Committee for Revenue and Finance in Islamabad. I'm going to start, if I may, by asking Justice Saeed to address us first. Justice Saeed, if I could ask you to turn your mind first to the question of ADR and FDI from a judicial perspective. In your mind, what are the things that you see a government such as Pakistan can concentrate on in addressing the relationship between ADR and FDI by supporting ADR in the courts?
Well, thank you for that introduction, Duncan. And the question, is one which, can lead to quite a number of things being said in response. But perhaps one has to look at what FDI actually is and understand that, at least from what I understand of FDI, it connotes somebody who is a foreign investor who intends to make a long-lasting investment in Pakistan rather than someone who is just perhaps engaging in a standalone transaction. So they'll be investing in the country either by establishing a business or collaborating with an existing business, and that would mean that they would have larger interest in the overall dispute resolution mechanism that exists domestically. A number of themes were already touched upon in earlier panels about how you need to have ADR statutorily embedded across various areas where disputes could arise. The speaker from Turkey had illumined us on how they have combated the vast quantum of cases that were pending in their court system, and how that was eradicated largely through the establishment of mediation centers and utilizing mediation as the dispute resolution mechanism of choice. And as it happens, I was part of a delegation to Turkey which had gone perhaps a year and a half ago. And there we had visited some of these mediation centers, and we were informed that by statute, disputes such as consumer protection cases, labor disputes, and as we were informed today, even rent cases have to necessarily be taken through a mediation process before a party can come to court. As far as Pakistan is concerned, certain legislative steps have been taken to enforce a system of mediation, but that has been left mostly as a matter of consent as between the parties. The courts have limited ability to, push parties towards mediation. They can actually call upon them to mediate, but at the end of the day, if they choose not to, what is the recourse which the courts would actually have? Because you also have to factor in that we don't really have a well-entrenched system of costs. I remember attending a conference on ADR way back in perhaps 2005-6, and Justice Mushir Alam was then the Sindh High Court, perhaps Justice Sabiuddin Ahmed was the Chief Justice. And at this conference, as a naive junior lawyer, I think I stood up and had the temerity to ask as to why anybody would venture towards mediation or alternate dispute resolution in our litigation landscape, where somebody can come to court, pay a very nominal amount of court fees, and even if the case is lost at the end of the day, after having exhausted perhaps a decade of the court's time, they would just walk away with very little by way of consequences. So, a cost system needs to be introduced as a deterrent to vexatious litigation to ensure that the backlog that afflicts the courts is attended to, but also it's one thing that would actually prompt people to take ADR seriously. If they realize that every dispute isn't necessary to be litigated through a court of law, and this is a means of dispute resolution which ought to be explored, and if it is not explored in good faith, that there would be some consequences that the court can bring to bear against them, then I think ADR, whether it's mediation or conciliation, whatever model we hope to implement, would definitely have a much better chance of success. Beyond that, obviously, there are several other basic measures which any government can take, whether it's sensitizing the litigating public towards the means available for them to resolve their disputes through whatever ADR platforms as are implemented, bringing the various stakeholders on board, whether it's the bar councils, bar associations, trying to create awareness amongst legal practitioners that this is the way forward. It's not a measure which necessarily ought to be resisted by them. So, I think that's those are a few of the core issues which governments could address. As I said, the statutory steps, awareness building, training, and so on.
Could I ask a brief follow-up question, if I may? In London, where I practice, the commercial court is a highly restricted court. It generally sits on arbitration cases and other cases in which the amount in dispute is at least £2 million, if not more. And the judges actively push cases to other divisions of the court in smaller cases. Do you think in Pakistan there's scope for a narrower, restricted division of the court that could deal with arbitration in large commercial cases?
Well, it's interesting that you asked this because as far as at least the Sindh High Court is concerned, we have what's called the original jurisdiction which the Sindh High Court enjoys. And that is structured on the basis of a pecuniary value, and it's a rather nominal amount compared to what you mentioned as far as the commercial court in London is concerned. Here, the Civil Courts Ordinance had originally structured this jurisdiction by regulating it in such a manner that any suit which had a value of over 25,000 rupees would originate in the Sindh High Court, irrespective of the subject matter. And now, over a period of time, that valuation has been enhanced to maybe 6.5 crores, 65 million, as you would call it. But again, it's not rationalized by reference to what the nature of the underlying dispute is. So, even though the Sindh High Court is really the commercial court, at least in the city of Karachi for all practical purposes, the jurisdiction is overrun with cases that have no commercial nexus whatsoever. So I think there is definitely a lot of scope for commercial courts to be created, and we have, in a judgment which has been rendered by the Sindh High Court, we have called for the provincial government to take the necessary legislative steps by tabling appropriate legislation before the provincial assembly to carve out a commercial court structure. which is actually more rational in the sense of being based on classification rather than simply a pecuniary value.
Thank you very much, Justice Saeed. Can I just apologize for my mistake earlier? I said additional judge of the Sindh High Court, and I should have said confirmed judge of the Sindh High Court. Thank you for graciously not correcting me, but I apologize for my mistake. Kevin, can I ask you to come in at this point and just to address the matter from the perspective of Singapore? We know that Singapore, as we heard earlier, is now one of, if not the leading place for international arbitration in the world. Has Singapore successfully supported and promoted FDI through its alternative dispute resolution regime?
Thank you, Duncan, and thanks for all of your yeoman's work on putting this panel together. You've really helped all of the panelists. It is great to be in Karachi and to really see the excitement and hunger for the dispute resolution regime here. What I'm going to try to do is view things through the lens of Singapore and how it can be applied to Pakistan. And so let's start with Singapore. This is a country that is actually smaller than the geographic area of Karachi, resource scarce, and somehow Singapore is now the third largest recipient of FDI in the world, behind only the US and China. So how has Singapore done this? There's a variety of factors, but when you look at what Singapore has done, it's the dispute resolution regime that really is the glue that holds this together. And maybe I'll start with the proposition as well that it does not necessarily need to be the dispute resolution regime in the host country or the home country. When I look at some of the jurisdictions in the ASEAN, India is a very good example. Much of their FDI is being premised on dispute resolution in Singapore. The idea is to create an attractive regime where investors are comfortable moving their money into that jurisdiction. I think it's also important to look at what happens after the drafting of the dispute resolution clause. We all know that arbitration is the preferred mechanism to resolve cross-border disputes. This is uncontroversial at this stage, but what happens and what is the state doing after the investment is made with the companies in terms of providing incentives, education of employees, getting local buy-in? These are all very important factors that Singapore has done quite well in terms of attracting this foreign investment. I often say when I go around the world that with dispute resolution, what Singapore has done is turn dispute resolution effectively into an industry. So not only does FDI and a robust dispute resolution regime bring in that very necessary investment into the economy, which is attenuated in the post-COVID regime, but there are enormous benefits for the local economy when you become a dispute resolution center. There are very compelling studies out of Toronto and Hong Kong that show the economic impact of international arbitration in these jurisdictions. Now, as a Canadian, I think that I can speak with some authority on Toronto as a seat of arbitration. It is generally not mentioned, say, in the top 3 or 5 destinations for arbitration. But in 2011, more than a decade ago, they estimated the economic impact of international arbitration at around 200 million USD year on year. Obviously, we have our own calculations in terms of Singapore, Hong Kong, even higher. So it's also very important for the country itself in terms of developing your own dispute resolution infrastructure. Now, if you're not, say, having a neutral third-party jurisdiction that's handling the dispute resolution to encourage this FDI, it then becomes incumbent on that host state, incumbent on Singapore to be able to provide that neutral, predictable forum. And the test that I always look at for why an investor would want to invest in Singapore, if it's choosing one of the Singapore institutions, is the idea, could we go up against a very consequential and influential Singapore entity and still get fair justice? And I believe that that dynamic and that perception exists in Singapore. If you look at some of the court pronouncements and the language used, this is really the defining quality of Singapore, that the rule of law is going to be applied without fear or favor. It doesn't matter if it's a foreign company, a host, or a domestic company. That is how the rule of law is applied. And Duncan, maybe I'll just give a last word on the importance of international commercial courts and how all of these dispute resolution regimes fit together. There's a 2010 study done by the World Bank when they're talking about instilling investor confidence. and it's access to a wide range of dispute resolution mechanisms. And more in 2024, we're seeing dispute resolution, not just arbitration, not just mediation, not just litigation. It is rather the confluence and the integration of these factors. I can recall in 2014 when the Singapore International Commercial Court was set up, many practitioners were bemoaning that this is the end of international arbitration. Now all of these disputes are going to go to the International Commercial Court. In fact, the effect has been quite the opposite, how the Singapore International Commercial Court is adding to the international arbitration regime in Singapore. At SIC, we now have a model clause that provides for the Singapore International Commercial Court as the curial court. So if you look at the Singapore High Court, already thought to be perhaps the most pro-arbitration bench that we have in the world, but if a foreign investor wanted to go to an international commercial court where you have international jurists, that option is there as well. So it is difficult in a relatively short intervention to say how you encourage FDI, but what I think is uncontroversial is dispute resolution as being this key cog or overall glue that instills investor confidence and attracts that foreign investment.
Thank you very much, Kevin. It's not a coincidence that all of the OECD, the Doing Business Guide, the World Bank, prioritize as one of their primary considerations the question of enforcement of contracts within a reasonable time. If you can't enforce contracts within a reasonable time, doing business becomes harder, foreign direct investment is deterred, and it sounds from your description of Singapore and indeed Toronto that is the focus. It's to deliver justice and the enforcement of contracts within a reasonable time. Can I come to you, Shabak, to look at this from the point of view of a lawyer advising both Pakistani clients and international investor clients? Can you give us a couple of key steps that you think could be prioritized in Pakistan in terms of using ADR to promote FDI and investor confidence?
Yes, thank you, Duncan, and ladies and gentlemen, and the honorable judges of the superior courts. When you're advising a foreign client looking to make investments here, they don't have an appreciation of the culture that exists within the country and the things that they need to be aware of. Many clients that I've dealt with are very contract focused. If they feel that if the counterparty has agreed to a particular provision, that is the end of the matter and that is it. But it is often difficult to convey to them that it may be written in your contracts that you're going to get this money, but tomorrow when you're trying to get this money out, you might face difficulty because of the foreign exchange environment. Or today, the government may be offering you certain incentives. However, these incentives may be of a politically sensitive nature, and 5 years from now, they may become a major source of a crisis as to why your project comes into the public eye. And they have a bit of trouble understanding that how to deal with these issues and how to even engage with the government. Because often what I see from the federal government and the provincial governments as well is that it is a very short-sighted approach. They don't engage in the discussions about the disputes that they might have 5 years from now or 10 years from now. They're only engaged in pushing things through and being able to get that news article out that, we are bringing in $300 million in the next 1 year. Not whether they're going to be able to secure the return of that or what benefit or controversy that might come into later on. And this is an aspect that foreign investors must learn to address if they want to do business in Pakistan, if they want to do business that is less controversial and dispute-free. They must have this additional dimension to their approach.
Thank you very much. That's a great insight from the point of view of advising foreign clients and the challenges that they face. Hassan, would you like to come in with your thoughts on the same subject? Perhaps choosing one or at most two particular steps that you think could be prioritized here?
Sure. Thank you, Duncan. Thank you, ladies and gentlemen, honorable justices. It's an honor and privilege to be here. I think I'll jump right into it, and very pertinent what everyone said. As far as the legislative framework is concerned, and as far as the laws, and actually the first point of contact is us as law firms, because when a foreign investor comes in, you get a standard questionnaire asking about all the laws related to foreign investors in Pakistan. What we don't focus upon is the criteria of ease of doing business. Now, while we have an excellent Forex framework which enjoys free repatriation of foreign investment, the advice that we're giving should be, while you can incorporate a company and have foreign shareholding, that foreign investor needs to run helter-skelter and get security clearance. That foreign investor would need a work permit for people to actually work in Pakistan. To renew that work permit, those employees or those subjects would need to leave Pakistan to renew that work permit. Visa on arrival. We've heard a lot of talk on visa on arrival, but it's quite an administrative nightmare to obtain a visa to enter Pakistan. So I think while the framework and the legislative, the laws are all in place, I think what we need to also focus on is ease of doing business. And I'll paint a slightly positive picture on how Pakistan has dealt with it. I mean, Pakistan was on the grey list as far as the FATF was concerned. And all the government departments did get together and managed to present a case to the plenary in which they showed that their compliance standards were enabling enough to get off the grey list. So there is a pathway, but I think the focus needs to be more on the practicality of the situation as opposed to really the legal aspect, because the legal aspect is somewhat covered.
When the FATF crisis was happening and we were trying to get out of the grey list, I was part of a couple of conferences, discussions, roundtables about what can be done. And there were stakeholders present from various government institutions and various private organizations. But the approach and culture problem still seem to persist, in that the focus of all the discussions seem to be about how to get out of the list, rather than what do we need to do to ensure that we have robust mechanisms to counter money laundering and financing of things we don't want financed. It was just a matter of getting out of this list, meeting this criteria, passing this law, not about the future. Again, that short-sightedness that we really need to address.
Thank you very much, Shabakt. It's very interesting to hear the lawyers in private practice with a fierce focus on ease of doing business and clients' practical concerns when coming to Pakistan in order to invest. Can we move now to look a little bit more closely at the enforcement of arbitration awards? One feature of this weekend has been that there has been an admirable and understandable focus on dispute avoidance, particularly mediation and particularly negotiation. But the fact of the matter is that in a number of cases, settlement proves impossible and awards have to be rendered by arbitrators. But believe it or not, clients don't see very much value in that piece of paper. They want the money that's written at the bottom of the page. I'm going to turn to you, Kevin, if I may, briefly, and just ask you, in brief outline, to summarize for us the Singapore approach to enforcing international arbitration awards, please.
Sure. Well, maybe I'll tweak that slightly and make it the SIC approach. Sure. And I think this is the same for you as counsel. Enforcement starts at the commencement of the arbitration, or maybe even in the getting up before you actually go green and file a notice of arbitration. That's how we look at it institutionally. And the reason why you choose an institution rather than ad hoc arbitration, in most cases, it's going to be more timely, more cost effective. And if it's an institution such as SIC and ICC, we have that structured administration where there's the review, the scrutiny of the award before it's issued. I see in many cases, say in an ASEAN jurisdiction, there might be unique procedural requirements that are specific to that jurisdiction. So if you have an international tribunal that is not familiar with that jurisdiction, it could be, for instance, say whether punitive damages are against public policy in China. What are the service requirements in Vietnam? These are some of the many reasons why you choose an institution to administer the arbitration. I think that what we try to do in our outreach efforts and our capacity building is make sure that firms and clients have also went through the asset tracing exercise. Because, Duncan, we can think that, say, if it's an Indonesian respondent, a Pakistani claimant, we can think that enforcement is going to be in Indonesia, but we can't be sure. Maybe that Indonesian entity has assets in the UK. So from an institutional standpoint, all we can do at the beginning is ensure compliance with the seat of arbitration. That's the first port of call, but also give effect and potentially advise the tribunal on what we see the enforcement requirements being in Indonesia or in the jurisdiction of the respondent. It's also a key reason why you really have to give thought to the seat of arbitration that you choose. The seat of arbitration, that is where the application is set aside is going to occur. That's where a party may be making applications during the pendency of the arbitration. This is why, as good as we think that we are as institutions, the seat of arbitration may be more important than the institution that you choose.
Thank you very much, Kevin. Justice Saeed, could I come to you and bring this question of enforcement back to Pakistan and your point of view as a judge? Could you offer any comment on the enforcement of arbitration awards in your jurisdiction? Specifically, if you feel able to comment on it, whether the courts are striking the right balance in terms of speedy, supportive enforcement and the appropriate supervision of arbitration awards.
Well, Kevin, if you're speaking more about international arbitral awards, then yes, we have a 2011 Act which provides for the recognition and enforcement of New York Convention awards. There is now a pro-enforcement bias, which is something which has been brought to the fore in several judgments which have been rendered by various high courts and also now emphasized by the Supreme Court in a very recent judgment. But it comes back to what I was saying earlier, you know, having a judge being cognizant of the fact that there is a pro-enforcement bias is one thing, but when you have courts which are burdened with an overwhelming amount of litigation on their docket, then their capacity to effectively enforce a foreign award is impeded because of the delays which are inherent in the system. So, you know, a lot of times foreign awards don't come up for hearing as quickly as they should. So coming back to the Sindh High Court, perhaps we haven't really enforced too many foreign awards since the inception of the 2011 Act. I had asked our registrar and our legal research cell to give me the number of cases where foreign awards had been enforced under the 2011 Act, and the picture was quite dismal, to be honest. So I think the courts actually need to be strengthened. They've already been sensitized as to what the scheme of the New York Convention is, how the scope for objections is very limited, how it's important to have a minimalistic approach in terms of being reluctant to interfere with awards unnecessarily and enforce them. But at the end of the day, you have to have the benefit of time on hand. So if you have a docket of maybe 50, 60, 70 cases and the enforcement matters come up towards the end of the day, I think a lot of times delays are caused because of this process, which needs to be streamlined. So it's not simply a fact that the courts aren't up to it. It's because the system as a whole needs to be reevaluated and restructured.
Thank you very much. Just to follow up that issue, something that was said recently by the president of our commercial court in London in answer to a question was that there's only so much the judges can do. The delivery of speedy justice is, in fact, in part a collaboration between the lawyers who appear in the courts and the judges who adjudicate on the cases. And I wanted to follow up by asking you whether you had any proposals or suggestions for the ways in which counsel and the lawyers who appear before you could assist the court to deliver more speedy justice to support the desire of investors for resolution in a commercially realistic time.
Well, again, coming back to what I said earlier, at the end of the day, you'll always have only one party which perhaps desires a quick and expeditious conclusion of the case. One party will always be seeking to, resist the enforcement of the foreign award or domestic award till kingdom come, if they can manage it. So unless you have some coercive tools at your disposal in terms of, imposing costs on counsel or parties that are found to be protracting the proceedings unnecessarily or being delinquent in their duties to the court, you'll find that judges are somewhat handicapped in that respect. So again, it comes back to the first question that you posed: what can the government actually do to strengthen the courts in their ability to move things forward? I think if we had a statutory mechanism in place which provided for costs to be imposed across the board, that would be a step in the right direction. Yes, we can come up with practice directions for lawyers as to how they should present their briefs, but again, I think that would perhaps only have a limited benefit for the time being.
Thank you very much. That's very interesting. I'd like to ask Hassan, please, whether on that subject you can indicate to us, without giving away any secrets perhaps, whether there are strategies or techniques that you use to help your clients achieve justice through ADR in an efficient time, so as to avoid justice delayed and therefore denied.
Without giving out any secrets,
Yes.
I'll give you a very candid answer on this. At least the way that, I've been trained to advise is not everything needs to go to court from the get-go. There are specialized forums, there are regulators, there are appellate tribunals, there is an entire process whereby which a dispute can sort of reach some sort of amicable finality, as opposed to start with the court system, which is perhaps needs a little bit more administrative management, because the case management system here is a little bit different. So if one exercises these courts of first instance, and especially with regard to FDI, the company regulator, for example, does not have the ability to adjudicate shareholder disputes. That goes to the company court and the high court. However, having said that, it has an array of powers to adjudicate several other disputes. What tends to happen is everything company related finds its way to the high court. So there is a way to just start elsewhere and perhaps go upward from there.
Thank you very much. Shabak, can I just ask you to come in here, just by way of introduction to this? One of the techniques which I see used a lot is to try to force a scenario where the disputing party has to pay first and argue later. So that could be by way of an order for security for costs. It could be by way of an order for security for the disputed amount. You can draw an analogy with construction cases where, certainly under English law, if you have an adjudication which orders payment, payment must be made immediately, even if you then go to an arbitration where the issue is relitigated and decided the other way, and then the money goes back. Thinking about those sort of techniques, are there any that you want to add to what Hassan has said?
I don't know if I'm going to be proud of what I'm about to say. One of the things that, unfortunately, as a practitioner in Pakistan, that you have to do when you're advising a client is try and figure out some way to get an injunction. We don't know what that's going to be, but it has to be something that will hurt the other side in some way or the other and force them to the negotiating table. Because you cannot rely on the final relief or the threat of final relief being enough of a motivator to bring parties to the negotiating table. And oftentimes, to do that, you have to try and argue for injunctions against bank guarantees, against payments, against cash against documents, against things that in rest of the world are certainties. And it is unfortunate, but that is the only way you find that that's the only way to bring someone to the table.
Thank you very much. We're going to move now from the subject of court intervention to the matter of investment treaties. and specifically ADR provisions in those. Shabakt, I'm going to come back to you to kick us off on this subject. Clearly, the subject of bilateral investment treaties, as I mentioned at the outset of this session, it is quite controversial in the sense of its attractiveness to international investors and its direct effect on the appetite for investment. Can you give us a little bit of insight into where Pakistan stands in terms of its support for investors' ability to enforce any rights that they may have under investment treaties?
This is a very interesting question because Pakistan's stance seems to have radically shifted over the last few decades. From being a pioneer of the bilateral investment treaty, being the first country to execute a bilateral investment treaty in the 50s, we, in the aftermath of the RICO-DIC arbitration, became incredibly fearful of possible actions by foreign investors. They stopped ratifying treaties. I think there's 16 or so treaties that are still awaiting ratification, and there's talk about renegotiating treaties and terminating treaties, though we haven't done that. But there is fear that we might have another RICO-DIC. But and it's not a solution, because the kind of protections that you have in a bilateral investment treaty, while not to the extent of what you have in a treaty, you do already recognize to a great extent in your local law, whether that is the 1974 Investment Promotion and Protection Act, or you have the 1992 Economic Reforms Act, which protects against expropriation. You have a lot of these measures already in terms of non-discriminatory treatment, in terms of bringing yourself on parity with local investors. But the BIT has unfairly, I think, become a target. But the BIT is not the problem. The problem, which people don't want to address because it requires a much more long-term solution, is to understand why RICO-DIC happened in the first place. There was an issue with the terms as well as to how fair people thought they were, but there was also a sort of approach that once we defaulted on that, and there was a claim from Tetian, the first approach in response to that claim was to fight it. I recall that at one or two occasions early on, there was some avenue for negotiating an outcome there. But the government, perhaps again with its short-sightedness, decided it's time to put the fists up, fight this, and leave the issue for the next government to take care of. And so at every stage, from challenging the arbitration, from challenging the quantification, from challenging the costs, at every stage the country continued to throw resources at fighting something out which they could have right at the beginning recognized as partly being responsible for and coming to a mediated, negotiated, settled outcome which would have saved the country years of pain and now a settlement which was pretty much obtained on gunpoint.
Thank you very much. Perhaps a role for... Of course, Justice Saeed, yes.
I think just to add to what Shabakt was saying, I think this is perhaps a product of our adversarial mindset and the kind of training which we have here as lawyers. Rather than trying to come up with a solution to the problem, I think we just try and prolong the dispute as long as we can. And as he was saying, oppose every measure, any order which is passed, you have a tendency of appealing that irrespective of what your chances are at the end of the day, because you just want to linger the matter on as long as possible. And while that pays dividends here within our local jurisdiction, it ends up as a disaster when you're litigating or arbitrating before an international tribunal, because there the consequences are inevitable.
Thank you very much. And just to agree firmly with what the learned judge says, one of the aspects of cases that I have handled where this can be seen directly is where, by fighting a case, you push the claimant party into seeking litigation funding. Once they do that, their position becomes very, very different, because suddenly they're in a position where they're going to be giving up a substantial proportion of whatever they win to pay to the funder in order to allow it to secure the profit that it is seeking to get from the relationship. When you cross that Rubicon, it's very difficult to come back because the negotiations take on a different hue. So by way of practical example of illustrating what the learned judge said, there is a threshold beyond which bilateral investment treaty claims, in my experience, get much more entrenched and difficult to resolve. Kevin, can I ask you to comment on this area? What sort of a role can international arbitration institutions play in investment treaty cases? And how do investment treaty appetites and attitudes affect you as leading one of those institutions?
I would start by saying that I agree with everything that has been said on this topic. It's actually a very interesting time for Asian states. Many Asian states are moving from capital importers to capital exporters. It's an age of inflection for ISDS overall. The choice of whether a state wants to operate by way of treaty or investment contract under the New York Convention or Washington Convention, what is the way forward? It's critically important to SIC as an institution. I've been participating in Working Group 3 for as long as I can remember. I don't even know how long it is now, 7 years, because SIC wants to get involved in investment arbitration. We get a fair number of disputes involving states. Typically these are contractual disputes, but what we wanted to do and what we introduced on 1 January 2017 was try to find maybe the next way forward for the resolution of investment arbitration. So we released the SIC investment arbitration rules, which effectively are a blend taking our commercial expertise and applying it to the treaty space and the investment arbitration space. It's been included in an FTA. We're in talks with other governments, and this is something that is important for us. But I think that the real change that is difficult to predict is how Asian states are going to move forward. I find myself going around the world wondering why so many significant entities and states are resolving their investment disputes or their commercial disputes in lands far, far away. I think that the bargaining power for Asian states and Asian corporates are changing, and now these states can be resolved closer to home. So it's an interesting time for ISDS generally, but I think particularly in Asia.
Can I now, by reference to one particular protection offered to investors under bilateral investment treaties, just ask Hassan to come in on a subject that you offered to mention when we were preparing for this session. One of the major protections that one sees in treaties, and sometimes in contractual agreements, is an agreement not to restrict the repatriation of profits or assets in any way, to allow an investor freely to take out any proceeds of its investments. Hassan, can you say a word about how in Pakistan foreign exchange control and the removal of profits is policed, and whether protections given to investors can be difficult to enforce in that area?
So it's actually quite simple, but I guess it's misunderstood to a large extent. Now, the law allows free repatriation on foreign investment. If you read the law, if you read the foreign exchange manual, if you read that act, you can bring in your foreign investment and you are entitled to take out dividend, no questions asked. Now, where is the issue? The issue is that we are facing a liquidity crisis. There is a reserve problem. And just to give you context on figures, right now the State Bank of Pakistan is sending out dividend. They've just finished 2022 and they're starting on 2023. So you're a whole year back in the game as far as it's going out. But there is no permission required in taking your foreign investment out of Pakistan. There's permissions required also similarly on another side to register a loan in Pakistan. It's a very document heavy process, and also there is an intermediary. The banks actually face the central bank when filing all these documents takes place. So sometimes there is a gap in communication in doing that process and getting it right from day one. So what ends up happening then is, if the process isn't kind of logged and registered within the central bank system, another misconception that it takes place is just because the foreign investor is registered on the company regulator, repatriation will follow. But this is a central bank specific procedure which is led by the banks, which sometimes involves issues of non-registration, which is why, coupled with the liquidity crisis and the reserve crisis, dividends don't flow out in the normal course. And then, the foreign investor at the time of exit is running helter-skelter to get this pre-registration that was required to be done, let's say, even 10 plus years ago, to be done at that juncture, and that gets problematic.
Thank you very much. Shabat?
Yes, thank you. That is, I agree with all of that. We must also understand the issues why that has resulted. When Pakistan decided to liberalize its foreign investment regime, and except for just few limited sectors allowed investment into everything, we were opening the economy up, and that's a great step. But when it came to what projects the government looked at and worked on in terms of bringing investment in, initially there was a bit of a drive towards manufacturing and revenue generating sectors, but the equilibrium seemed to settle on projects that were cost centers, bringing in money and projects to set up things like power plants that cost money to continue operating. So very important indeed, but if you don't back that up with investment into increasing production capacity, you will never actually bump up your exports and foreign exchange earnings to be able to pay off those debts. And so while we opened everything up, there wasn't any proper guiding hand ensuring that the right sectors were being focused on from a long-term perspective.
Thank you very much. I think at this point, although I could keep asking questions of the panel all evening, we should give the audience a chance to ask any questions. If you'd like to ask a question, please put up your hand, and when asking, please just state your name and indicate whether it's directed at any particular member of the panel. Yes, sir. Should be a microphone coming to you.
Hi everyone, thank you Duncan, and thank you to all of the panelists. My name is Adil Lalani. I'm a disputes lawyer here in Karachi at Hathaway Partners. My question, or rather my request for a comment, is directed to Kevin and Justice Syed. Kevin, you spoke to us and illustrated how the Singapore International Commercial Court occupies a specific space within the Singapore judicial system with regard to transnational and international commercial matters. And Justice Syed, you spoke about how enforcement is unfortunately a pressure point or a key issue with regards to how these cases don't often make it to the top of the docket list or the cause list, and therefore these matters are not really prioritized. So in your collective view, do you think perhaps a similar structure of an international commercial court just for the purposes of either enforcement or perhaps even ancillary matters related to arbitration awards, would that be a viable structure to adopt as part of our judicial system here? And if so, what would that structure potentially look like? Thank you both.
Thank you for that question. As I had mentioned during my earlier address, this is a subject which I have already spoken on from a judicial standpoint. There was a case which came up before the Sindh High Court. It's a reported judgment. 2 lawyers had actually come and challenged the original jurisdiction of the Sindh High Court as it is configured. And in that judgment, we had called for while adjudicating the matter, we had called for the data. And when you look at it, there are only perhaps a maximum of 40 judges in the Sindh High Court at any time. As far as the original side is concerned, you can perhaps devote 5 or 6 judges to that side. And that is where all the civil suits and civil proceedings are taken up. And when we had called for the data, we were astounded to see that as many as perhaps 22,000 civil suits were pending. And those have to be attended to by those 5 or 6 judges who also hear these matters in rotation as per the roster that's prepared from time to time. And if you look at the civil court structure, again in Karachi district, there are 63 courts functioning, and the pendency there was 15,000 civil suits. So there is a complete mismatch as far as the two jurisdictions are concerned. That's why we said, please consider reconfiguring this original jurisdiction, either get rid of it, or if you say that this jurisdiction was conferred in the Sindh High Court in recognition of the fact that it's an epicenter of commerce and you need a commercial court, then by all means, of course, reconfigure it as a commercial court with reference to some rational classification based on the species of litigation. So I think there is definite scope for creation of a commercial court. We had called upon the provincial government to table appropriate legislation, and we had left that judgment whilst remarking that we were sanguine that the provincial government would fulfill its constitutional responsibilities to ensure the effective dispensation of justice. But till now, I'm sorry to say that all we've been met with is a deafening silence. So, still looking forward to an awakening at some point. Let's see when it comes.
Maybe just very quickly, I think what the Singapore International Commercial Court has been able to do in Singapore is put real arbitration specialists, sector specialists on the court. You may have seen that David Rivkin was just elevated to the Singapore International Commercial Court. You have practitioners and arbitrators like Professor Doug Jones, who's a construction expert. But importantly in Singapore, it's a division of the High Court. So it's not an apex court. I think the idea is to get these international arbitration specialists to hear these arbitration cases in the first instance, and it's worked well in Singapore, but obviously the judicial structure of every jurisdiction will be a bit different.
And
Yes, Judge.
before ending, I just wanted to compliment our friends in Lahore. The Lahore High Court has actually taken measures to implement a commercial court structure in the province of Punjab, and I'm told that that is working well, and we were just hoping that a similar model could have been adopted in Sindh, and I think that's definitely the need of the day, not just here, but perhaps across the length and breadth of the country, so that even commercial matters emanating from arbitral proceedings can be effectively enforced more expeditiously.
Thank you very much. I'm going to have to bring it to a close at that point because of time. Can I just say, from a personal point of view, how uplifting and encouraging this whole weekend has been to see members of the judiciary, lawyers, international lawyers, engineers, business people, all on the same stage, all pulling in the same direction and seeking to elevate the practice of ADR and its effect on business is hugely encouraging, and it's been a privilege to be a part of it. So thank you very much, and would you join me in thanking our excellent panelists in the usual way, with particular thanks to the Honourable Mr. Justice Saeed for joining us on this panel.